Good afternoon, everyone. It's my pleasure and honor to welcome you to our discussions from Drinko Hall today, which will be our annual Supreme Court preview, discussing important cases upcoming in the term of the U.S. Supreme Court. Here with me today are several esteemed colleagues and experts in different fields that will be addressed by cases decided by the court. And what we'll be doing is we'll be discussing each of those cases. Each of the faculty members joining us today will have about 8 minutes to discuss the cases, which will reserve some time for us at the end to ask questions. If you have questions, please feel free to put them into the chat or the Q&A. It's my privilege to be your moderator, and so I'll be examining those questions and then giving them to the faculty members toward the end of the conversation. This is, of course, a really interesting time in the history of the Supreme Court. It's a time of transition. And there are some really important cases up. We're going to be discussing 5 of those cases. But before I turn to Professor Ruth Colker, who I'll introduce in just a moment and will be our first speaker, I'd just like to wish everyone who is celebrating Yom Kippur, they'll have an easy fast and a good year. So with that, I'll turn to Professor Colker. Professor Colker is a nationally renowned expert in the fields of constitutional law and disability rights. She is a distinguished university professor here at Ohio State and holds the Heck Faust Chair in Constitutional Law. Professor Colker.
Thank you, Dean Davies. So we're each going to spend 8 minutes today to try to do our best in describing these complicated cases before the court. So I'm going to start with Fulton versus City of Philadelphia, which is a case from the Third Circuit. The case involves religious freedom. What happened in that case is that the city of Philadelphia has contracts with various groups that help it deal with foster children and the placement of foster children. And one of the groups that it had a long-standing relationship with was Catholic Social Services, which I'm sure most of you have heard of. They do a lot of work in that field. And Catholic Services had a policy that in placing children for foster care, that one thing that they considered, which they were allowed to consider, was the family status of the family that they were placing the child into. And they favored families that were headed by married couples. But consistent with their Catholic faith, they didn't consider same-sex couples who had been lawfully married in the state of Pennsylvania or elsewhere as getting that preference. And so they therefore did not act consistently with the city's policy that they were not allowed to discriminate on the basis of sexual orientation in implementing the city's policies about how foster care placement should take place. So this case was heard in the lower courts, obviously already. The Third Circuit ruled in favor of the city of Philadelphia, concluded that this case did not present a First Amendment problem, that if Catholic Charities wanted to continue to work with the city of Philadelphia, they would have to abide by their non-discrimination policy. And an important fact in the case was that the city continued to work with Catholic Charities for other types of work. They just refused to continue to work with them in this one particular area because their policies and how they handled foster care weren't consistent with the city's policies about marital couples. So the Supreme Court has accepted cert on this case, and it's going to be argued November 4th, 2020. So much will have happened around then. The court accepted cert on 3 grounds. Because of the limited time we have, I'm just going to focus on one of the 3 grounds, which I think may be the most determinative or most interesting ground. So the second issue that the court granted cert on is whether Employment Division versus Smith should be revisited. And let me explain why that matters and what the court might do there. In 1990, the Supreme Court decided Employment Division versus Smith. It's a case involving people who, as part of their Native American tradition, were using a substance that was illegal under state law, and when they were fired because of a conviction, they weren't able to get unemployment insurance. And they argued that the state law violated their First Amendment religious freedom rights, but the law itself was neutral. It didn't refer to any particular religious view. It just had this rule about if you were convicted that you couldn't collect unemployment insurance. And so in Employment Division versus Smith, the Supreme Court concluded that if all you could demonstrate is that this neutral state policy had a disparate impact against your religious belief, that was enough to trigger strict scrutiny. And Employment Division versus Smith was a very unpopular decision by the United States Supreme Court. In a response to that decision, the Congress enacted the Religious Freedom Restoration Act in 1993 by nearly unanimous majority. When does that ever happen? But what RFRA did is it said, even if policies just have a disparate impact, they should have to be justified by a very strict scrutiny. And basically what Congress tried to do was overrule the Smith decision. So those of you who know anything about constitutional law know that Congress isn't allowed to rewrite the Constitution. The court might revisit a decision under the Constitution. The Constitution can be amended, but Congress doesn't get to rewrite constitutional principles. So RFRA was struck down as applied to state and local government. It still is constitutional as applied to the federal government, which goes beyond the scope of what I can talk about today. So in this particular case, the Catholic Charities couldn't challenge this local ordinance under RFRA because RFRA has been struck down as not applying to state and local government. They were suing the city of Philadelphia. So instead, they have to bring their claim under the First Amendment, under the Smith Doctrine. And under that doctrine, although it's not impossible for them to win, it would be difficult for them to win. Most of the courts that have looked at the application of the Smith Doctrine will require some evidence that this law was passed out of animus against a particular religious group. And it's very difficult to show any animus in this particular case because the city continues to work with Catholic Charities, just doesn't work with them in this one context involving foster care. So the courts accepted cert on the issue of whether it should revisit Smith. And if it does revisit Smith, it could choose to put in place more protective rules that would make it easier for religious entities to make this kind of religious liberty claim. There's some reason to think that this court is a court that is sympathetic to such claims. In the Obergefell case involving gay marriage, in which Chief Justice Roberts dissented, in his dissent, he said that that decision of the court created serious questions about religious liberty. So he has been on record saying that he thinks that religious liberty claims should be considered, despite the fact now that gay men and lesbians have the legal constitutional right to choose to marry someone they love. There have been other strands that you're probably familiar with from the court also suggesting that the justices think that religious liberty should be expanded. This past summer, many of you know that Justice Gorsuch wrote the opinion in Bostock versus Clayton County, which is the Title VII case involving sexual orientation issues. And in that case, Justice Gorsuch said how these doctrines protecting religious liberty interact with Title VII are questions for future cases. So he also posited, I rendered this decision that is pro-gay rights, but the religious liberty issue is still out there. So it wouldn't be hard to think of 5 members of this current court that are interested in rethinking the Smith Doctrine. And so for me, the interesting question will be, if they choose to go down that path, how do they rewrite the Smith Doctrine? Do they go so far as to endorse the rule that Congress crafted under the Religious Freedom Restoration Act, or do they come up with something else? That is certainly a hard thing to predict. But that's what I'm looking for, is guidance from the court as to how it's going to handle religious liberty claims in the future. So that's my little 8 or 9 minutes on Fulton versus City of Philadelphia. Thank you.
Thank you, Professor Colker. As you see, we're going to jump from important topic to important topic, much as the Supreme Court does. So we're going to turn next to a much different case, moving from intersection of freedom of religion and free exercise issues, as well as discrimination, to a case or a set of cases that involve questions of the Alien Tort Claim Act. To do that, we're going to turn to Professor John, who is the President's Club Emeritus Professor of Law here at Ohio State and an expert in human rights. Just as a quick reminder before we turn to Professor Quigley, we'll be holding all Q&A until the very end of the discussion once we've walked through all 5 cases. But we do have time set aside to walk through questions. So please feel free to put in your questions to the Q&A box, and we'll hold those until then. Professor Quigley.
Thank you, Dean Davies. This case is Cargill and Nestlé, 2 corporations against Doe. Doe is actually several individuals who were working in the Ivory Coast on coca plantations on which products were produced that were then purchased by Cargill and Nestlé for use in chocolate products in the United States. And the case arises under a statute originally adopted in 1789 to give the federal courts concurrent jurisdiction with state courts over torts that were in violation of the law of nations. The case now raises the issue of whether that applies currently. And as you can imagine, the situation, the factual context of the application of the statute is quite different in the 21st century from what it was in the 18th century. In particular, the entire concept of human rights has come into being, so that a tort in violation of the law of nations now potentially includes all of human rights. The statute applies to aliens. That's why it's called the Alien Tort Act. That is, the plaintiff must be an alien. So it's aimed at ensuring that the federal courts provide a forum if an alien is injured in violation of the law of nations. And it was focusing mainly on piracy in the late 18th century. That is, if an alien were harmed by pirates on the high seas, that they would have a cause of action in the federal courts of the United States. The factual setting here is extremely important economically because it involves virtually the entirety of the chocolate products, cocoa beans that are used for chocolate products in the United States. The Ivory Coast produces something like 35–40% of the world's cocoa beans, but the decision will affect those coming from anywhere. The case was decided in the Ninth Circuit and was decided in favor of the John Does. So Cargill and Nestlé lost in the Ninth Circuit. They need to overcome the decision of the Ninth Circuit, which means that they will need 5 votes in their favor. There are 2 questions presented. Cargill and Nestlé are saying that corporations should not be liable under the Alien Tort Act. So they're saying that this is an act that makes for liability only if the perpetrator, the tortfeasor, is a private individual, but it does not extend to corporations. The second question presented, if the court thinks that the act does apply to corporations, the second issue is whether the activity of the corporations is sufficiently connected to the United States, because in a prior decision, the Supreme Court said that the Alien Tort Act does not apply if the tort is committed entirely outside the United States. And in that case, it was a foreign corporation that was being held, but so it was a corporation that did not have a connection with the United States. So now the issue is whether, if it is a U.S. corporation, whether that is a sufficient connection to overcome what the court said in the previous case, namely that the act doesn't apply to torts committed outside the United States. So Nestlé and Cargill purchase from farmers in the Ivory Coast. They also have activities on the ground in the Ivory Coast because they buy from a large number of very small farmers. So they're not just contracting from with a farmer who then ships to the United States. They're buying actually in the Ivory Coast. So they do have some activity in the Ivory Coast. So those are the two questions presented. The court could decide on one or the other. This is a case with huge international ramifications for the United States. Around the world, other governments are putting pressure on their corporations to ensure that the conditions of work are adequate in plantations of this sort. And the allegation here is that the individuals were in effect in slave labor, that they were not free to leave, that they were kept under conditions of where they got minimal food to eat, and that therefore it's a violation of international law in that way. And that's what brings it within potentially the Act of 1789. I should say we have a course that's going to be taught on business and human rights in the spring semester. Andrea Schemberg, one of our alumni, who is a world expert on this subject. So it's a subject very important if you're going to be practicing criminal, any kind of law that relates to international crimes or to corporate activity. That will be a very important course. The case is being argued by a fellow named Paul Hoffman for the John Does, by Neil Katyal and Andrew Pincus for Cargill and Nestlé. Those are our traditional major litigators in the Supreme Court. So it's got a very good litigation in Stor. It's on the docket for December 1st, so there's a good likelihood that there will be the new justice on the bench by then. There were 3 judges from the 2013 case who are almost certain to vote in favor of Cargill and Nestlé. So Cargill and Nestlé need 2 more to prevail. So they need 2 out of Gorsuch, Kavanaugh, and Barrett. So the likelihood, I think, is that they will get 2 of those 3 just from the prior kind of decisions of all of those judges. But it's not a foregone conclusion. The 3 liberal judges, Sotomayor, Breyer, and Kagan, are very likely to go in favor of the John Does. But I think with that, I will end.
Thanks, Professor Quigley. And before we move on, just one quick clarifying question. The plantations or farms that were involved here, are they small farms? Are they plantations? What's the size of these agricultural facilities?
They're quite small. So typically they're small farmers who have a plot. So the term plantation is a misnomer. Thank you for clarifying. That's why Cargill has people on the spot that purchase from these farmers and then ship the cocoa beans to the United States.
Okay, very helpful, thank you. So you'll notice there's no coincidence in a tie between the first 3 cases. They all involve children. The first case we've discussed involving adoption. The second discussed just now by Professor Quigley, addressing child labor. The third case involves criminal punishments for juveniles. So to that, for that case, we're going to turn to Professor Doug Berman. Professor Berman is the Baker and Hostetler Chair here in law at The Ohio State University. He's also the director of our Drug Enforcement and Policy Center. So, Professor Berman.
Thank you, Dean, and thank you everyone for attending. I'm going to actually read the question presented in the case of Jones versus Mississippi, which comes directly to the court from Mississippi, and then I'll spend my time trying to unpack what this question presented means in all of its particulars. The question is whether the Eighth Amendment requires a sentencer to make an affirmative finding that a juvenile homicide offender is, quote, permanently incorrigible, end quote, before imposing a discretionary sentence of life imprisonment without the possibility of parole. I may use the term LWOP, that's kind of the vernacular for when we're talking about life imprisonment without the possibility of parole. And this is a constitutional case dealing with the Eighth Amendment. As students who've taken my sentencing classes know, for about a half a century now, the Supreme Court has interpreted the Eighth Amendment and its prohibition on cruel and unusual punishments, place a number of limits on and the procedural rules around death sentencing. But it's only been very recently that they've interpreted the Eighth Amendment to regulate any kind of prison sentencing, non-capital sentencing at all. In fact, all the precedents up to the recent decade has been very deferential to whatever states want, whatever extreme imprisonment lengths, even LWOP for a first drug offense they approved for adults. But building on some of the death penalty precedents, in 2010, the Supreme Court for the first time limited categorically a prison sentence in a case called Graham versus Florida. That was a 5-4 ruling, and it actually had Justice Kennedy writing the majority. So already I'm setting up the fact that without Justice Kennedy there, we don't know quite what to expect in this new Jones case. But in Graham versus Florida in 2010, Justice Kennedy wrote for the court that the Eighth Amendment categorically prohibits LWOP, life without the possibility of parole sentence, for any juvenile offender if he or she was convicted of a non-homicide crime. So anything other than homicide, the court said you can never give LWOP no matter what the procedures were. At the time, there was only estimated to be about 200 or so juvenile offenders who had gotten a life without parole sentence for non-homicide offenses. And so the impact, though significant, especially jurisprudentially, wasn't that great on actual cases. But that led to pressure and debate about whether a similar rule ought to apply to homicide offenders. And actually within 2 years, surprising some, the Supreme Court took up that issue in Miller versus Alabama. In 2012, in Miller versus Alabama, again, a 5-4 ruling, the same 5-4 divide at the time, though now with Justice Kagan writing for the majority, holding, and actually it was Justice Sotomayor had come on the court at that time, and Justice Kagan as well, obviously, so they were with the traditional liberal majority, here holding that the Eighth Amendment precluded mandatory life without parole for any juvenile offender convicted of homicide crimes. So that's got a little nuance to it. We're talking about homicide crimes now, but they didn't preclude all LWOP for juvenile homicide offenders, just a mandatory process. And of course, the way that often played out in states that the court talked about was that a juvenile would be brought into adult court, and in many states, there's a mandatory life without parole for the worst kinds of murder. And so it wasn't really that a bunch of states had specifically said, we want juveniles to get mandatory life without parole, but the function of juvenile worst offenders being brought into adult court and then adults being subject to mandatory LWOP for the worst kinds of homicide led to there being, by some calculations, as many as 2,000 juvenile offenders serving life without the possibility of parole as a result of a mandatory system. Then the question became, well, does that ruling in Miller apply retroactively? Oftentimes, procedural rules only apply prospectively in the future. And so it was debated in lower courts, and the Supreme Court took this issue up in 2016 in Montgomery versus Louisiana. Here now, the Supreme Court ruled 6-3, Justice Kennedy again writing the majority, but interestingly, Chief Justice Roberts, who had dissented in the earlier cases, was now joining the perceived liberal majority along with Justice Kennedy, holding that that Miller ruling, precluding mandatory life without the possibility of parole for homicide offenders, that should apply retroactively, that was actually a substantive rule designed to sort of make sure that no child, no juvenile ever wrongly got LWOP unless they actually deserved it. So that's the lay of the land, and there's been much litigation over, well, who can get LWOP as a homicide offender after these Miller and Montgomery cases. The Supreme Court provided no clear instructions as to how that decision is supposed to be made by lower courts, and so that's been fought out purely endlessly in lower courts. There was this dicta, though, in Montgomery that said that LWOP should only be given for the rarest of juvenile offenders whose crimes reflect permanent incorrigibility. And that dicta has now been elevated by many defense litigants saying, hey, we shouldn't be able to be punished with LWOP unless and until there is an affirmative finding on the record by a judge that this defendant reflects and its crimes reflect permanent incorrigibility. That's the terms of the debate now in Jones versus Mississippi. Jones is saying, Brett Jones is saying, that finding was never made in my case when I was resentenced to LWOP. Mississippi is saying, well, you got a resentencing hearing after Miller and Montgomery, and the judge heard all your evidence, and in fact, a bunch of mitigating evidence about how you weren't a terrible kid, and he still decided to give you LWOP, and so that's good enough. There doesn't need to be a formal specific finding. Among the things interesting about this case is originally this issue was going to be addressed last term in a case involving one of the most notorious juvenile killers, specifically Lee Malvo, who was one of the DC snipers, who at age 17 was involved in a series of serial killings with 10 victims. But Virginia, interestingly, changed its laws about resentencing while that case was pending. That mooted that case. And so now we have Brett Jones as the case that the Supreme Court's going to resolve this issue through. And he's a much more sympathetic case. He was living in Mississippi after fleeing an abusive home in Florida. He was only 15 years old while with his grandparents in Mississippi. His grandfather found out that his girlfriend had slept over one night. They got into a fight in the kitchen. Brett Jones stabbed his grandfather multiple times, ultimately killing him. That's a crime which I don't think most folks would say amounted to permanent incorrigibility quite the same way as the Malvo crimes. But interestingly, the judge, upon resentencing Brett Jones, heard all the evidence that he wasn't a bad kid and the circumstances of the crime, ultimately seemed to sort of have a presumption for life without the possibility of parole. Said he wasn't entitled, quote, to the benefit of leniency as provided in Miller. And that's really where this is all going to kind of hinge. Is there a kind of presumption against LWOP, which the court seems to be pushing toward, or is it really you can give LWOP without a formal finding in even what might seem like more mitigated types of cases? Wrapping up, we think that, I think certainly that Justices Breyer, Kagan, and Sotomayor, who's been on the defense side in this whole jurisprudence, is likely to require more from judges before they impose LWOP. Justices Thomas, Alito, and Gorsuch, who don't seem to be big fans of expanded Eighth Amendment, seem unlikely to vote for the defendant, more likely to be in favor of the state. But Chief Justice Roberts, as I mentioned earlier, was against the rule and was open to it being applied retroactively. He might be of a slightly different view. Justice Kavanaugh, I must mention, I believe his oldest daughter is 15 years old now, the same age that Brett Jones was when he committed this crime. Being a parent of teenagers maybe shape his view of kind of the teenage jurisprudence here. And then obviously, if we have an eventual Justice Barrett, she obviously has quite a history as with children as well, being the mother of 7. And so whether and how that may influence the current court on this question is one of the things that I'll be watching.
Thank you, Professor Berman. Just as a reminder, folks in the audience, if you've got questions, feel free to put them into the Q&A dialog box at the bottom of your screen. We'll be taking those questions as we get toward the end of the conversation of each of the cases. Good to have you put them in now, just as a reminder on that front. So we're going to turn from one area of the law that permeates society, criminal law, to another area of law that permeates society, administrative law. And for that, we're going to turn to Professor Chris Walker, who holds the John W. Bricker Professorship in Law here at Ohio State. And we'll welcome Professor Walker.
Great. Well, it's good to see some of you and hopefully hear questions from the rest of you. So I'm going to talk about the Affordable Care Act, which is back before the Supreme Court this term. It's been there before in 2 major cases, and then a number of other kind of cases that deal with some of the other provisions. For those that need a refresher, the Affordable Care Act often is referred to as a 3-legged stool. In other words, there were 3 critical components of the statute in order to make healthcare affordable for all in the United States. The first was to make it affordable for those with, in particular, those with pre-existing conditions. And so that was one of the major objectives of the statute, was in order to make it so that people can get insurance even if they have pre-existing conditions, so that the prices are right. To do that, though, Congress was concerned about the healthy people not buying health insurance, right? Or otherwise the moral hazard that you wait to buy health insurance until you get sick and have a pre-existing condition, and then you get insurance at that point. And so because of that, if you have this 3-legged stool, there were 2 other mechanisms put in place. One is that there were mandates put in place, both an employer mandate and the one we'll focus on today, an individual mandate, that everyone had to have health insurance, or you'd have to pay a tax or a fine if you didn't. And same with employers being required to provide health insurance for full-time employees. And then the third part of this was in order to kind of bridge the gap for those who weren't employed or did not have the finances to buy health insurance, there were subsidies included. These subsidies included like healthcare.gov or state-run exchanges as well, where if you bought in that exchange and you're below a certain income level, you would receive a tax credit. It also included expanding Medicaid in the states to allow to kind of capture those folks who wouldn't be able to meet the mandate with their own financial means. So when you're thinking about the Affordable Care Act, you have these the 3-legged stool. And if one of those legs is cut out, the argument goes that then the whole system falls apart. So we had our first constitutional challenge to this shortly after the law was enacted, and Chief Justice Roberts joined the majority to uphold the Affordable Care Act against the constitutional challenge. The challenge was brought under the Commerce Clause originally, the idea that Congress lacked the authority to require folks to buy health insurance. Chief Justice Roberts, though, decided the case under the taxing power that Congress has. In other words, he said the individual mandate is not a requirement to buy health insurance, a mandate, it's actually a tax. And this is important because when we fast forward to 2018, when the Republicans passed the tax reform legislation, one thing that they did is they eliminated the tax. They zeroed it out. In other words, they said this individual mandate, if you don't buy health insurance, you don't owe any taxes for not buying it. Not surprisingly, states like Texas and plaintiffs that were the same, on the side of Texas brought a lawsuit and claimed that the Affordable Care Act, that the individual mandate was now unconstitutional because it was no longer a tax. And that's the case that's made it up to the Supreme Court. Now that it is no longer a tax, because there is nothing taxed for it, does that make the individual mandate unconstitutional? And then the larger question from that is that if the individual mandate is unconstitutional, does the 3-legged stool have to all fall? In other words, does the court have to invalidate the entire Affordable Care Act, or at least the other 2 legs of the stool, in response to it being unconstitutional? Now, the Supreme Court is actually considering 3 somewhat related questions. The threshold question is, why do these individuals have standing to bring a lawsuit? And this is one that puzzles me quite a bit. In other words, the individual plaintiffs who brought a lawsuit are claiming that they have standing because they've been injured, because they aren't going to buy insurance, and yet they have to buy insurance. In states like California, and the House of Representatives intervened and said, what are you talking about? You're not injured. You don't have to pay anything. It's gone. I mean, technically you're violating the law, but people violate the law all the time, technically. But if there's no actual consequence, you're not injured. You don't have standing. I don't know how the Fifth Circuit got around this, and I'm not really sure how the Supreme Court will. The states have also claimed they have standing not because of the individual mandate, but because the individual mandate's invalidated. The whole Affordable Care Act falls according to their view of the statute, and therefore they're going to be affected by this. Not usually how we think about standing for even states, that you look at kind of broader things. You look at whether you have standing to bring the exact claim that's being brought. So I'm quite skeptical on that front. The second question is whether the individual mandate is unconstitutional. I remember Chief Justice Roberts only joined the majority because he viewed it as a tax and not an exercise of commerce power. It'll be interesting to see what happens on that front. Even before the passing of Justice Ginsburg, you already had 4 votes on the other side of this, saying that if it isn't a tax, then it's invalid use of the commerce power. My guess is perhaps Chief Justice Roberts would go in that direction as well, because the tax was zeroed out. Now, what does that actually mean? Nothing. I mean, if a new Congress came in and reinstituted the tax, it would now become a tax under Chief Justice Roberts' view. It would now be a proper exercise of congressional power. So which way the court cuts on that, I don't really see that as actually having a real world impact. Where you do see a real world impact, though, is that Texas and now the Solicitor General of the United States have said that if the individual mandate is unconstitutional, the 3-legged stool falls, so the entire Affordable Care Act needs to be invalidated. Of course, now you're really grappling with a tremendous change to our healthcare system. It's not a coincidence that the Trump administration has been trying to say they can save health insurance for those with pre-existing conditions through executive order. Not really, they can't do that, but they're trying to, right? Because they realize that this is really going to be a big problem if the whole Affordable Care Act is invalidated. Now, this last question comes down to a doctrine called severability. In other words, what do you do when one part of a statute is unconstitutional? Do you invalidate the entire statutory scheme, or do you sever out the parts that are unconstitutional? I can't go into it more in the Q&A. I don't view this as a close case on severability. I think it's very easy to just sever out the individual mandates now that it is not a tax. Congress, when the Republican tax bill was passed, didn't eliminate the entire Affordable Care Act. It just zeroed out the tax. In other words, they didn't envision that the whole Affordable Care Act would go out the window. And I think I would be very surprised if there were more than a couple votes on the Supreme Court, even if someone like Justice Barrett were added, that would embrace such a drastic remedy of invalidating the entire Affordable Care Act just because the tax has been zeroed out from the individual mandate.
All right, thanks so much, Professor Walker. So we'll now turn to our last case, and just as a reminder again, if you would like to put any questions into the dialog box at the bottom of your screen, we're happy to take those. We're going to hear from one last speaker about a final 5th case, and then we'll have a bit of time for conversation and Q&A. And for that, we'll turn to Professor Guy Rube, who is a faculty member here at the College of Law. I also want to give a hat tip to Professor Rube, who has helped organize this. This event, of course, is sponsored not only by the law school, but co-sponsored by the American Constitution Society, as well as the Federalist Society. And Professor Rube has done a lot of work helping bring us together today. So I want to thank him, and I'll now yield the floor to Professor Rube.
All right, thank you, Dean Davis. So I'm going to talk about Google v. Oracle. This case has the potential to be the biggest copyright case we have seen in decades, maybe in more than a century. And not just because it's a lawsuit for over $9 billion. The case is the oral argument is next week, next Wednesday. And there are 60 amicus briefs that was filed in this case, 60. And some of them by huge group. I signed a brief with 72 other copyright professors. They are briefed by 80 people, 90 people, huge group. So what I'll try to do in the short time that I have is tell you why so many people pay so much attention to this case. Why is this case so important? The case deals with Android, the operation system that most of us have. 75% of the cell phone in the world run Android. It's the most important operation system in the world, not just for cell phones. It was developed around 2005, 2006 by Google. And when Google developed it, they made a decision that is the focus on this case. They wanted to allow other people to work with their stuff. They said, we will put the Android operation system out there, but we want to invite programmers to write application to run on our cell phone, right? That's how Android works. Google doesn't write the application, they just write the operation system. To make it easy, they took an existing software language called Java and just rewrote it. They said, we will rewrite Java, we will do it on our own and just offer anyone who wants to write an app for Android phone or Android TV or Android smartphone, smartwatch to just use our language. So far, so good. But then they copy a tiny part from the existing Java code. What they copy is called the API, Application Programming Interface. And I'm going to try to explain in 30 seconds what that is. It's actually a difficult concept to explain to those who are not programmers. So think about Java as a huge library of resources. And every software engineer, anyone who wants to write in Java, can use those resources to write their code. And Google said, fine, we will write those resources. We will take all that labor and all those costs to create our own library. All right, but what we want is the name of the books in the library, the name of the function to stay the same. The reason being is that anyone who is used to work in Java, we want them to be able to use our library. So we want basically to provide them the same names, the same name of book. They want them to be on the same place on their shelves, basically, to be able to find them. We will write the books themselves, but we want to copy the system that allows them to find those books, to find those resources in the huge sea of resources that you give software engineers. All right, so that's why they did it. Why did they think it was legal? They had a ton of legal counseling. Also, it's a huge project, and it's a minefield of IP rights when it's come to Android. So why did they think that that was legal? They have many reasons. I'll talk about the two main ones which are related. The first argument is copyright is supposed to protect the expression, which is like the books in my metaphor, and not the way to find them. The method of how to use the books, which is the name of the book, the name of the function, that should not be protected by copyright. That's argument number one. It's based on a doctrine that's called the merger doctrine, that the Supreme Court didn't visit since the 19th century, but it's a really important doctrine. The second related argument says interoperability. The idea is that when two software work, they need to work with each other. So the tiny part in the software, in my software that allow your software to work with it, that is not protected by copyright. And there are a few lower court decisions that said that. All right, that was their theory. Didn't help them. In 2010, Oracle, who now owns Java, another huge company, sued them for copyright infringement. And it got to the lower court. The lower court, they got to a judge also who is actually a programmer, and he said, oh, this is not protected by copyright. Went to the Federal Circuit on appeal. The Federal Circuit reversed, said, I don't see why not. You copy stuff, look like copyright infringement to us. So they reversed, but they say, well, Google might have a fair use defense. Fair use is the most important defense in copyright law. It says that if you take stuff that is either small or not very harmful or very creative, you do something very creative with it, you might still not be infringing. They send it to the lower court. Now, in the last 20, 30 years, a fair use is usually decided on motion of summary judgment, basically is decided by judges. However, in this case, it went to the jury. And it was a full jury trial. And at the end of that full jury trial, the jury came back and says, fair use. So Google won, great. Went back to the Federal Circuit on appeal. And now the Federal Circuit did two things that are very unusual. First, for the first time, they did a very long analysis is what kind of deference do you need to give to the jury? And they concluded that fair use, it's almost every question in fair use is a legal question. Therefore, the jury don't get any deference. And once they did that, they reversed the jury, which is extremely rare. This is maybe the second or third time in our history that the jury decision on fair use is reversed. And there are hundreds or thousands of fair use decisions. So it's very unusual. All right, now the Supreme Court takes the case and they have two questions before them. And maybe the most important part is which question they are going to attack. The first question is the really, really big one. And that, do those API, are they even protected by copyright? And this is why you get 60 amicus brief and hundreds of people signing them. Because our entire software ecosystem, and software is everywhere, right, is built on the notion of two software can talk with each other without a license. Think about the Zoom software that I'm using right now. Zoom can run on Microsoft, on Apple, on Google, on LG, on Samsung, on all those devices, and whoever wrote Zoom did not need a license from all those companies to run on their platform. Now, that's the world we are in right now, and if Google wins, that's the world we will continue to be. If Oracle wins, we will probably, on this question, we will probably be in a completely different world, in a world in which you need a license for one software to work with another software. That's a completely different world than what we are used to. It's kind of work for lawyers. So as lawyers, that's good business model. But for the industry, it completely changes what software industry is based on. So that's why everybody is writing about that. So that's a very difficult question. Supreme Court didn't visit it since the 19th century. Anything related to that, there was never, there is no decision on copyright of software in the Supreme Court ever. And so this is a big one. But the Supreme Court has an easy way out, and I think they'll take it, and let's talk about fair use. And in fair use, there is an easier way out, and let's talk about deference, and talk about the easier ways to reverse the federal circuit for the Supreme Court, which I think what they'll do is saying, you did not give enough deference to the jury, therefore we, the Supreme Court, don't tell you if it's protected by copyright, we don't even tell you if it's fair use. We just tell you the jury made a decision, stick with the jury. That's an easy way out. There were funky clues last year about that, and then a huge clue a few months ago when the Supreme Court asked for rebriefing on the 7th Amendment. It says, please tell us, you the parties, what do you think how the 7th Amendment, right, for jury, affect all of that? So I think that's a huge giveaway, that's where the Supreme Court will go, which is slightly disappointing for us as copyright scholar, but I think that's the path of less resistance for the court. Last 30 seconds, let me talk about Ruth Bader Ginsburg for the last few seconds. Copyright cases on the Supreme Court are not political, in the sense that it's not conservative versus liberal. We can talk about that a lot, why you can be a conservative or liberal and support broad or narrow copyright. However, there are camps. One camp in the Supreme Court argued that copyright should be narrow, give the users a lot of right, give the copyright owner very little right. Justice Breyer is the leader of that camp. The other camp says, no, copyright should be broad and users should have very narrow right. And the leader of that camp for the last 20-something years, which makes her the most important justice in copyright law for the last 20-something years, was Ruth Bader Ginsburg. So her passage, first of all, it takes a vote from Oracle. It might take more than one vote because she might convince other justices who are not copyright experts on the court to go with broad copyright. So I'm really looking forward to see how that affects both this decision and the decision that the court will have in copyright law in the next 2 years. Thank you.
Thanks, Professor Rube. And I actually want to start with that question. Obviously, the passing of Justice Ginsburg and the potential confirmation of Judge Barrett weighs heavily on the court. I want to turn to Professor Colker for just a moment and ask whether she thinks that change in justices may impact the outcome of the case she discussed.
That's a great question. Justice Ginsburg had the strongest view on the courts about the importance of the separation of church and state. And therefore, the consequence of that was to have a narrower view of the liberty interests of religious organizations. So really anyone replacing her would probably be helpful to those who are trying to make religious liberty claims. But in this instance, obviously, from the little we know, it would appear that that would be likely the case. So I don't think there's any doubt that with the passage of Justice Ginsburg, that this court is even more inclined to support the kind of arguments that Catholic Charities is making in this case. I think the question is on what basis do they win, not really whether they win. And there is, I didn't mention it, but there's a First Amendment issue in the case, but the compelled speech doctrine is pretty narrow, so I wasn't expecting the court to go down that path. And they could just resolve a circuit split about how to consider religious liberty claims without rethinking Smith. There's a number of more narrow paths that they could take, but I would think the Catholic Charities lawyers are feeling pretty confident before the Supreme Court right now.
Okay, thanks, Professor Colker. And I'll invite our other three panelists, since two of them have weighed in on this question about whether the change in justices may be pivotal in their case. I know, Professor Walker, you clerked for a swing vote on many cases, Justice Kennedy.
Yeah, I think in the, this Affordable Care Act challenge, I would just be shocked if we have a decision that invalidates the whole act. So I don't think that the new justice will change that. Obviously, Justice Ginsburg joined Chief Justice Roberts' opinion that upheld the entire Affordable Care Act. So whoever replaces her will likely be one vote on the other side. I haven't looked at the nominees' writings too closely on severability, but I find that severability argument to be pretty weak. In fact, she might even be one additional vote that the plaintiffs lack standing, which would be interesting.
Professor Berman.
I mean, what's interesting is it's really Justice Kennedy's departure and replacement that creates a lot of uncertainty in the Eighth Amendment space, because on all the juvenile sentencing cases, on a lot of death penalty cases, there was sort of a block of 4 justices eager to put restraints, and that included Justice Ginsburg. And it was often, well, how far will Justice Kennedy go? And I don't think it's coincidental that since Justice Kennedy retired and was replaced by Justice Kavanaugh, there's been no cert grants. I think the liberal 4 were not sure if they could get either Chief Justice Roberts, who's thought, was thought to be the swing vote in Kennedy's departure. And I also think, as kind of I mentioned before, that Justice Kavanaugh we don't know that much in this space, though, his history suggests he's not particularly pro-defendant, especially on an Eighth Amendment frontier. Justice Gorsuch is so interesting in this space because he tends to be very in favor of traditional procedural rights, which is where Justice Scalia and Justice Thomas still sometimes are, but they've never been for expanded Eighth Amendment rights, especially when they kind of substantively limit what the state can do. Jones' case, the Miller ruling before, is using the Eighth Amendment to create a procedural rule. And so which way that might shape, Justice Gorsuch as a possible swing vote, that's why I'm actually very much looking forward to argument and an ultimate decision, because they'll tip their hands on these issues, not just for this case, but probably their views going forward.
Perfect. Professor Quigley, anything to add in terms of the Alien Tort Claims Act?
Yes, in all likelihood, the case goes in favor of Cargill and Nestlé. Even had Justice Ginsburg stayed on the court, because I think they would have been able to get 5 votes. The 3 justices who were there on the prior decision, that's Roberts, Thomas, and Alito, they all think that the Alien Torts Act applies only to actions within the United States territorially. They use the statutory construction maxim that when Congress passes an act, it is presumed to apply only in the United States. Of course, this act was to apply to piracy, so I've never been able to understand why they could say that, but that's what they said, and they're still on the court, and they have 3 votes. Gorsuch and Kavanaugh, I think, may come up with a slightly more sophisticated reason than that, but still would probably vote in favor of Cargill and Nestlé.
All right, terrific, thank you. So Professor Berman, let's go back to you for just a moment. A couple of questions have come in the chat about Jones versus Mississippi. A couple of them are related to the standard of incorrigibility, and just if you could describe exactly how one shows what that means and sort of how it would apply in this context.
Yeah, I think among the reasons I would be inclined to predict that Mississippi wins this case is the particulars of how you would operationalize a required showing that a juvenile be permanently incorrigible, or really any other finding, some other dicta in other cases talked about whether the crime reflected transient immaturity. Again, how we determine that, and of course there's a double whammy here. I'm not sure how we would determine that, a couple years after the crime, when usually we get to sentencing in a high profile, type of killing involving juveniles. We can think about the Parkland shooter, for example, as an example of a high profile recent killer who was a juvenile, almost a juvenile, a little bit older, but that could raise some of these kinds of questions. How would we decide these sorts of factors in an equivalent type case? But then how do you decide that 20 years later, especially if, as is often the case, the juvenile has been serving an LWOP sentence, but been very good and has matured, as inevitably we all will, in 2 decades anywhere, let alone in prison. Lower courts have been all over the map on this. And the one last point that hardcore constitutional criminal procedures folks will like, if the Supreme Court were to announce a defined standard of a required finding before giving a juvenile homicide offender life without the possibility of parole, the court's Fifth and Sixth Amendment jurisprudence would suggest that that finding might have to go to a jury and be proven beyond a reasonable doubt, that it would be inappropriate for a judge on their own to make that determination. That Fifth and Sixth Amendment due process and jury trial rights would mean any fact like that that's defined to limit whether you can get this longer sentence. And I think all of those intricacies are likely to lead this current court, especially to be saying, no, the rule is just judges have to think about youth. As long as they've given that some thought, they have broad discretion to do whatever they want